Welcome back, focused learners. Okay, today we're tackling a massive, literally life or death question. Who is actually in charge when a disaster strikes the homeland? We're going to peel back the layers of a really complex constitutional tug of war, one that dictates exactly how our country responds to catastrophic emergencies. So here's our roadmap for today's explainer. First, we'll look at when disaster strikes, then rebellions and the Constitution. Next, the great debate of militias versus standing armies, followed by testing the boundaries, and finally, the intervention principle. Section 1. When disaster strikes, the modern dilemma. All right, let's dive right into this. Picture this. It's 2010. During a national-level exercise simulating a nuclear detonation in an American city, a deeply frustrated cabinet secretary literally slammed his fist on the table in the Situation Room and yelled, "Why can't we just go in there and tell the governors what to do?" That quote right there, it perfectly captures the immediate, visceral frustration of federalism during a crisis. We actually saw this exact structural friction play out tragically during Hurricane Katrina. The fractured division of responsibility meant no single person was entirely in charge, kind of turning federalism into what the media called the legal face of failure. I mean, get this, at the height of the devastation, Louisiana Governor Kathleen Blanco actually refused President George W. Bush's pleas to officially request the federal government to take control of the state's National Guard. The tension got so intense that in 2006, Congress jumped into the fray. They passed a law authorizing the president to use armed forces to restore public order after a disaster, completely without state request or consent. Well, the response? All 50 state governors united to oppose it. They viewed it as a massive presidential power grab that would just cause dangerous confusion in command and control. The pushback was so severe, the act was repealed just 1 year later. Section 2. Rebellions and the Constitution. The constitutional catalyst. Let's move back in time to see how this builds. Our timeline starts in 1786 with Shays' Rebellion in Massachusetts. It started as a protest against high taxes, but the existing Continental Congress was completely unable to respond. This exposed a terrifying weakness, right? The existing government lacked the authority to maintain domestic order. This direct failure acted as the catalyst for the 1787 Constitutional Convention and eventually led to the Militia Act of 1792, which granted the president explicit power to suppress insurrections. So simply put, the absolute failure of the Articles of Confederation essentially forced the creation of a central government with the explicit power to step in. The founders realized that, hey, if a state couldn't maintain order on its own, there had to be a powerful federal backstop to prevent total anarchy. Section 3. Militias versus standing armies, the Great Compromise. The core of their dilemma really came down to two vastly different approaches to defense. On one side, you had standing armies, professional, full-time soldiers. While highly effective, many framers viewed them as inherently dangerous to liberty. On the flip side, you had state militias. These were your part-time citizen soldiers, farmers and merchants by trade. Framers like Luther Martin championed these militias as the true bulwark of liberty, seeing them as the absolute best defense against a permanent, tyrannical federal army. Now, what's really fascinating about this is how the founders resolved such an incredibly tense debate. They compromised. They authorized a national army to ensure security against foreign threats, but they kept state-commanded militias as a shield against domestic tyranny. The militias would serve as the sword of the republic, staying under the command of state governors, unless they were explicitly called forth by the president for very specific defensive reasons. But not everyone was thrilled with this heavy reliance on state militias. Take John Jay's warning in Federalist No. 4. He and Alexander Hamilton warned of a massive collective action dilemma. Like, if one state was attacked, would the others actually send their militias to help? Jay worried states might be flattered into neutrality by enemies, or simply refuse to risk their own safety. Plus, without standard pay or a unified command, relying purely on state-based defense was a logistical nightmare. They knew for sure that unity was absolutely essential for national survival. Section 4. Testing the boundaries, war and the Supreme Court. During the War of 1812, the friction in this system became glaringly obvious. The New York militia flat out refused an order from President Madison's commander to cross into Canada and fight the British. Their argument? Well, the Constitution allowed militias to be called up to repel invasions, but they unanimously decided that didn't mean they had to become invaders themselves. No way! They essentially vetoed the president's war plan on constitutional grounds. And it wasn't just New York. We saw a massive standoff between Massachusetts Governor Caleb Strong and President James Madison. Governor Strong refused to supply his state's militias, claiming his state felt no apprehension of an actual invasion. so he argued it was his duty to refuse the president's call. Madison, however, argued forcefully that an attack on one is an attack on all, warning that letting states just opt out would destroy the nation's unified defense. Ultimately, the states did acquiesce as the military threat worsened. Years later, Congress actually reimbursed Massachusetts for their state-directed defense measures, but they set a really crucial precedent in the process. The federal government would only pay when the president had recognized the exigency. This established federal primacy, making it explicitly clear that the federal government, not the states, ultimately decides when an external threat is severe enough to warrant a unified national response. So, the crucial point is that the constitutional answer finally arrived in the 1827 Supreme Court case, Martin v. Mott. A militiaman had refused to serve, claiming the president lacked the constitutional authority to call him out. The Supreme Court ruled unanimously. The authority to decide whether an emergency has arisen belongs exclusively to the president, and his decision is conclusive upon all other persons. That ruling legally cemented the president's immense discretion during major crises. Section 5. The Intervention Principle. The final conclusion. All right, this brings us to the absolute core concept of our explainer, the Presidential Intervention Principle. This principle holds that the president can, and sometimes must, intervene when state and ordinary judicial proceedings cannot or will not maintain order, public safety, or equitable enforcement of the law. Basically, when a crisis transforms from a truly local issue into a matter of national concern, the president has the constitutional and statutory authority to step in. And this brilliantly illustrates how history repeats itself. The militias of the founding era haven't just disappeared, they've simply evolved. Today's reborn militias are our state and local police, our firefighters, and our EMTs. They're the part-time and full-time citizen soldiers on the absolute front lines of homeland security. Because we rely so heavily on these local first responders, state power, state capabilities, and local expertise remain absolutely critical to our national safety today. So while the president undeniably possesses intervention authority during dire emergencies, whether that's an armed attack or a devastating hurricane, we really have to recognize that states and their governors aren't just frustrating hurdles to federal efficiency. Actually, they provide a vital, intentionally designed structural check on federal power. They preserve civil liberties and ensure that military intervention at home remains an absolute last resort. I want to leave you with this final, provocative thought to ponder. Does the division of power in a crisis guarantee our liberty, or does it fundamentally risk our security? It's the delicate, sometimes fragile genius of the U.S. Constitution that attempts to carefully balance the two when disaster strikes. Thank you so much for joining me on this explainer. Keep questioning, keep learning, and I'll catch you next time.